This is a public hearing of the Zoning Board of Appeals of the City of Evanston. The zoning ordinance directs this body to hear applications for major variations, special uses, and appeals from decisions of the zoning administrator. Depending on the type of matter, this board will either make a final determination or send its recommendation to City Council. Would you please read the roll?
Rogers.
Present.
Burns.
Present.
Cullen.
Present.
Gallimore. Gingold. McLennan. Weinberg.
Thank you. With 4 members present, we do have a quorum. Also present tonight are Planning and Zoning Administrator Lori Pearson and Assistant City Attorney Mario Tretto. This is a formal hearing and there are rules that govern our proceedings. Most importantly, only one person speaks at a time to accurately record the proceedings. Anyone who wishes to address the board regarding any matter on the agenda will have the opportunity to do so at the appropriate time. Our procedure is to hear from staff on the documents on file and then receive testimony and other evidence from the applicant or appellant. Next, persons who wish to make a statement regarding the matter may do so at that time. Any person with a legal interest in property located within 500 feet of the subject property may present evidence, reasonably question witnesses, or seek a continuance of the hearing. When all supporting and opposing testimony and statements have been heard, the applicant or appellant will be given the opportunity for rebuttal or a closing statement. Then the board will close the record and begin its deliberations. All testimony will be under oath. Although we do not apply the strict rules of evidence, please limit your testimony or statement to your personal knowledge. When you address the board, please state your name and address and be sure to sign up on the provided sheet. We are audio and video recorded. Please make sure that you are at a microphone when asking questions or making statements so that you can be properly recorded. All proceedings are subject to broadcast at a later date. Any matter not concluded at tonight's hearing will be continued to our next regularly scheduled meeting. We do have 2 items on the agenda this evening. The third item has been withdrawn. Is the applicant for 2727 Woodbine present? And for 423 Greenleaf?
Yes, we're here.
All right, thank you. With that, the first matter of business on our agenda this evening is to approve the minutes from our meeting on August 5th. Does anyone have any changes, edits to the minutes? I do have one, which is on page 4. The last paragraph has me making a motion, which I'm sure I did not do as chairman, so I would recommend that we find out who made the motion and make that correction. But that's the only change that I have noticed. With that, is there a motion to approve the minutes?
Except for the changes, there's a motion to approve the minutes. I make a motion.
Second.
It's been moved and seconded. All those in favor, please say aye. Aye. Opposed? I will notice that the member who is not voting was not present at the last meeting. With that, we will move into our cases for this evening. The first matter on the agenda is 2727 Woodbine Avenue, and I would ask that that please be read into the record.
Andrew Venamore, zoning case representative, applies for major zoning relief to construct a 2-car detached garage. The applicant requests a 2-foot rear yard setback where 3 feet is required, zoning code section 6828C4, and 3 feet between a principal and accessory structure where 10 feet is required, zoning code section 6462C. The Zoning Board of Appeals is the determining body for the case. Documents entered for the record include variance application submitted July 15th, 2014, standards form, zoning analysis, plat of survey dated May 2nd, 2014, site plan, elevations, images of property, aerial view of property, zoning map of property, Spark meeting minutes excerpt from August 6, 2014, and letter of no objection from adjacent property owner.
Thank you. If at this point I could have anyone who would be speaking to us in the matter of 2727 Woodbine be sworn. If you'd please raise your right hand. Do you swear or affirm to tell the truth throughout the course of these proceedings?
I do.
Thank you. And if you would please come forward and give us your name and address for the record.
Thank you, Chair. My name is Andrew Venamore, Venamore. My address is 612 Academy Drive in Northbrook.
Thank you. And if you would please tell us about your proposed project.
Sure, thank you. So the project this evening that's before you is to locate a rather minimally sized two-car garage in the rear of this existing property. The home at the moment has a rather small attached one-car garage, and the owners are intent on converting that space that's on the east side of the home into living space to form more part of the house. At the moment, this house that was built in 1913 is missing, the kind of the quintessential family room, and the idea is to convert that existing attached garage into the family room, and by doing so, as a result of losing that single car garage, they would like to locate a two-car garage on the property for their vehicles. Based on the size or the proximity between the rear of the house and that eastern property line, which as you can see from the survey is quite narrow, the owners have narrowed the size of the proposed garage to 18 feet. Basically a standard size garage, or a rather minimal standard size garage, is a 20 by 20. They've decided, in order to reduce the extent of the variation requests, to narrow that garage down to the 18 feet. In order to still get a place to put their vehicles off the street and out of the public view, but also, again, as I mentioned, just to make it a little bit more practical to get around the garage and also to reduce the extent of the variation request. The two requests before you this evening are for a separation of structures. The requirement from the ordinance is to have 10 foot between the single-family residence and any accessory building. In this case, we're down at 3 feet between the structures, and then a rear yard setback for the garage. The requirement is for 3 feet. That's being reduced to 2 feet. As I mentioned, even though those seem rather extreme, our goal was to try to make them less extreme by only doing an 18-foot wide structure. So although they are, particularly the separation of structures down from 10 foot to 3 foot is quite large, we tried to make it as practical as we could. So our hardship essentially relates to the layout of the house on the property. House was built in, we think, around 1913. At that point, obviously, there wasn't much consideration given to houses having much in the way of vehicle storage. So the garage that's on the property now, like I mentioned, while it's going to be converted to living space anyway, is rather minimal as it stands. So with the location of the structure on the property, there really isn't a lot of other space for a detached garage. Obviously, to the east, where we have Woodbine and Jenks, that's really the front of the house. You certainly don't want to be putting any structure out there. So this is essentially the only location that we can identify to practically put a detached garage. So we feel like we've done the best job based on the kind of limited parameters that the property is giving the homeowners. And while they are rather large variation requests, we did, as I mentioned, try to do the best job of limiting those requests. So we hope the board feels the same way, and I'd be happy to answer any questions that you have.
I have a quick question. What is the proposed change on the curb cut? You'll be entering off of Jenks still, I'm assuming?
That is correct. So the curb cut that essentially runs straight into the garage door now will be entirely removed. The driveway, the curb cut, everything will come out, will be resodded. The sidewalk will remain, of course. And then the new curb cut will be added further to the east.
And I know there was some concern about trees,
Correct.
mature trees on the lot, and you've accommodated for.
So right, the original thought was to, based on kind of the narrowness and the tightness of everything there, the original thought was to give a driveway that would allow a little bit more practical space there. However, based on the neighbours' concerns, we would have always been, I think, preserving one of the larger trees, but we've given that even more width now. So we've got a 9-foot curb cut that opens up into a 16-foot opening as it gets closer to the garage. So I think it's a 26-inch tree. the 26-inch tree and the 15-inch tree adjacent to it, both of which are, the 15-inch tree is certainly on the subject property. The 26 is one of those right down the property line trees. Both of those are now going to be preserved because of the narrowness of the driveway.
And because of the closeness of the garage and the house, was there any looking at providing an attached garage?
There was initial consideration given to that. What drove the direction that we are now presenting is two things. Cost for an attached garage is quite a lot higher than a detached structure. And separately, if we had attached to the back of the house, we'd still be before you anyway, because I wouldn't then have that accessory building 3-foot setback. I'd then have a primary structure setback on the lot, Laurie, I think is somewhere in the 20-foot range. And I would have encroached into that anyway. So we were, in trying to figure out, okay, how do we approach this? Whichever way we were to do it, we'd be standing here. It just, based on how things laid out and being able to get a conversion of the existing space into a family room, plus, kind of squeezing this 2-car structure in, it made more sense to go down that path.
Are there other questions from members of the board?
Yeah. How long has have their owners owned the property?
Earlier this year, so they are.
So they just purchased it?
They are May residents of this house.
Okay.
The Mrs. has been living in the city for about 10 years, and the Mr. for about 5 years.
Okay. So they bought the house with the intention of renovating it?
Correct.
Okay. So would you mind addressing for me the issue of it not being an owner-created hardship? Particularly, from my point of view,
Yeah.
they're taking away a garage to make living space, which means they're creating that hardship.
They are, the way that the ordinance reads is that it requires 2 parking spaces per lot. So the aspect of designing this use is to give them 2 parking spaces. Now, to the chair's point, did they consider doing an attached garage? Yes, that was an initial proposition, but as I mentioned, we'd still be here requesting relief for that rear yard setback. Plus, there would be a considerable difference in the cost for the project. So that still would have been a situation where they'd be in the hardship position where they'd have to request relief. So by putting the 2-car garage in there and still adhering to what the city requires, which is 2 parking spaces, they are, I think, still meeting that aspect. Is it self-created? The property itself and its orientation on the lot is creating a hardship because, as I said, if we'd come in here with an attached garage, I'd still be here asking for zoning relief. So, that was the big discussion when the salesperson came out to the site was, what can we do here? We'd like to convert, but we also need two parking spaces. So, whatever direction we ended up going in, we would still need to request the zoning relief. So, it's somewhat being created by the necessity to have the 2 parking spaces. So the ordinance is
so your supposition to us is that the family room is just taking up the space that you didn't use because you're building a 2-car garage.
The objective was to remodel the house. That was kind of primary interest.
Okay, so that's slightly different than what you were just telling us, driving the 2-car, the off-street parking as being kind of the main argument here.
The initial interest in the property was to remodel an old home. By doing so, that would, the idea was to convert the attached garage space into a living space because the home doesn't have a family room. Now, can you contend that a family room isn't a necessary use in the city? I mean, that's certainly a position somebody could take. But I think if you look at the way a lot of new homes are built now, and I think whether you live in a home that has one or not, it's a pretty common use to have a family room on a current home. So by converting that space and then looking towards still needing the parking spaces, whether I had attached the garage or not, you know, to provide that space. Just say if it was in a position of, you know, providing that secondary space and doing nothing else, that would still require zoning relief because it would encroach into that rear yard. It depends on how, so now my encroachment is 1 foot into that rear yard. Of course, I still have the separation of structures, which is a much bigger request. Whereas, you know, I don't know what the actual number would be from an encroachment into the required rear yard. It would probably be greater than 1 foot. From a percentage standpoint, maybe they'd be about the same. But the process would, you know, we'd still be here requesting that same, a measure of relief.
Other questions from members of the board?
No.
Was there anybody else who wished to speak to us on this particular matter? I saw a couple hands go up, so if you'd like to have a seat, Mr. Benamor,
Sure.
I'm going to ask them to come up and speak, and then you will have a chance to speak to us again. Did I swear you in?
No.
If you just raise your right hand, do you swear or affirm to tell the truth throughout the course of these proceedings?
I do.
Thank you. If you would please come up and state your name and address for the record.
We're the Osakadas. I'm Dennis and my wife Valerie.
And could you spell your last name, please?
Osakada.
Thank you. And your address?
1905 Jenks Street, Evanston.
All right, thank you. And if you could please just tell us whatever you have to tell us.
We had a couple of questions as well. Some of might answer some of our concerns, but we live across Jenks. Technically, I think Woodbine is the address of the property we're talking about, but the facing of the house actually faces us on Jenks Street, and I have a picture of that if you wanted one.
We actually have one in our packet of information, so we can
okay.
identify your house
And-
on our map.
And my wife and I have been before this group before when we tried to get our one-car garage into a space because our house, there's 4 houses that are actually, there were originally 2 lots that became 4 half lots. So we couldn't remember if we were held to a different set of measures because we weren't full lots. We were certainly not expected to put a 2-car garage in our half lot. As a matter of fact, our struggle was to get a structure built in this, essentially the same space, only across the street. And the concession being that we had to build our 1-car garage open. So it was like a gazebo carport. And I have a picture of that if you need that too. So I guess one of the concerns we have is technically, I think the address is on Woodbine, but visually, it really looks like the front of the house is what faces what we look at. And then, and then the only other thing we kind of remembered back then too was the concession we had made was because of a feeling of openness, because there was now 4 houses on essentially a 2-house property lot. And so part of my concern was how is that going to affect openness? And then, you know, if this gets approved, how can we get ours in case we move and somebody would like to enclose ours in a garage, as a garage? But those would be, I guess, our primary concerns. Oh, okay. My wife has other questions.
Let me just kind of address that we have a map that shows the properties, and these are not uncommon in Evanston, where a corner lot was divided into two and a second house was put facing what would be the side street effectively of the main house, even though the face of the house may be on that side street. So it looks like 1904 and 1905 are the two, your house and the one directly across the street are the ones that are the smaller
Correct.
lots on that. So we can see on our map exactly, the situation you're talking about.
Right. I think the lot of the space that was taken in the front easements on Woodbine, I think the actual house property might not be that different. I don't know. I have no idea. I mean, in terms of living property.
Right. So if you're,
I think that from our point of view, we do hearken back to our experience in front of the board and we had a very fiery meeting with our neighbors, whom we have all reconciled with. But one of the things they were concerned about is just sort of like having an open space garage that would have, bikes in it and all kinds of stuff that you would see from the street. And we were, in a sense, held to a higher standard because we did have a smaller lot, so we had to sort of ante up. The structure that we built cost probably 5 times as much as an enclosed garage from a garage, would have cost. It's made out of stucco. It's got cedar beams. We did our best to make them as happy as we could, and in the end, they were content. But our concern is, I guess my concern more than my husband's, is when we look across the street now, we see a charming house, and you see the garage that we already see on the street directly, the house directly across from us. If our neighbors, our new Venables, would build a quality structure that matched the house or that were attached to the house, we would be more comfortable with it. But as it is, it's, we don't know how they're going to remodel the existing, doorway to the existing garage. We don't know how it's going to look. For all we know, it could end up still looking like a garage, in which case we'll be looking at a garage door next to a very common-looking, garage, 2-car garage, and it'll give us 4 garages to look at. And I really do think that it would sort of bring down value for the property, actually not just us, but for even the property itself. If they were to even build their, finish off their family room and let everybody see how it would inform the decision about a 2-car garage better. But as it stands, personally, I'm not happy with the way things are progressing. I would rather make sure that the family room, that everything was more aesthetically pleasing and didn't have the chance of being a stable of garages in my line of view. Have I said that clearly?
I think you have. Are there any questions for either of the Osakadas? No? All right. Thank you very much for coming out. With that, is there anybody else who wanted to speak to us? I think I only see a couple people. So, if you get a chance to respond and sum up here. So if the applicant would like to come up and speak to us, you can say anything in summation, or you can ask questions of the Osakadas if you'd like.
Question, just more of a qualification. The owner actually went into the zoning department 3 months ago, to try and figure out how to maneuver through, and was told that before submitting any permits related to conversion of the space, that they actually had to get through the permitting piece for the garage first. Their interest was in converting the space, taking out the garage door, putting in the family room, putting in the windows, stuccoing the front, and then moving on to the garage. But they were told that you have to actually go about it in the reverse fashion because you have to have those 2 parking spaces. You can't eliminate spaces to then
Right.
have them in the future. So I think that was their focus was to do what you had requested first, but they're having to do it in reverse order. And the finish on the proposed garage was to, as you can see from the plans, they're going with a staccato board that will match the existing house. So the idea was to provide a structure, a detached structure that mirrored what the house is now, and the idea was to try and at least make it seem like it had been there for an extended period of time, as opposed to being a brand new structure sitting out there on its own. So I think that their intent was to do what the neighbor had indicated first, but unfortunately that's not what the zoning ordinance permits.
Well, and to be somewhat frank about it, I mean, that although we are concerned about what the finish of an outside building looks like, that is not really our purview. So with that, anything you would like to say in the summation to close out the record before we begin deliberation?
No, I mean, I think we understand the board's concerns. I think the neighbor has a valid concern. While the look of the exterior of the structure is certainly not within the board's purview, the owner's intent had always been to ultimately make the house appear like there was never a garage there, therefore with windows and stucco, and then make the garage appear like it always had been there, by having it look very similar to the house. So again, their focus had been in trying to make a practical solution to the difficult situation as far as that side of the property is concerned. And yes, it's busy in there, and the neighbor that we've worked with most impacted by this structure, as you can see from, I think, what was provided to the board, we went through all of her issues and made her comfortable with those. The setbacks are the only requested variations. It may seem like this, as I said, this end of the lot is kind of busy, but based on what's being proposed, we're still compliant with lot coverage, we're still compliant with impervious surface. So it's just, it is those setback variations that are, what we're being faced with tonight. Thank you.
Thank you. With that, we will close the record and the board will begin its deliberations. As with any case that we hear, there are a set of standards that we must find are met in order to approve any project that comes before us, and we'll walk through those. But before I do, I'd kind of like to get a general feeling from people on the board as to their thoughts on the particular project.
Do I always have to go first? Okay. Good Lord. So I have a couple of problems with this. I have a problem with it being a hardship that's peculiar to the property. These sorts of sizes of properties are typical throughout Evanston. And a house without a family room, for me, is not, I don't perceive that as a hardship when we look at Evanston in its totality and the variety of housing stock that should be here in Evanston. And that's part of the comprehensive plan, is to have a variety of housing. I also have an issue with the hardship not being self-created. For me, I see it as being self-created because they're trying to take that one-car garage space that is legally non-conforming. They can leave that one-car garage where it is and park in it and keep everything just the way it is. I see that their desire for making that a family room to be creating their own hardship.
Other comments from the board?
I mean, I agree with Mary Beth. Also, I think that you probably could have worked with the neighbors a little bit better so they, come up with a plan that they could support at this group.
Probably, am I the lone dissent that thinks it's fine? I think it's fine.
I think it's fine.
I'm not going to go into all the details.
Okay. I tend to agree with Mary Beth on the fact that I have a real problem with this not being an owner-created situation. If this had been a situation in which someone had lived in the house for many, many years, family had grown, that sort of thing, but the idea of basically purchasing the house and then coming and reworking the house right away, I have a bit of an issue with, because of the fact that we do try to keep a number of different types of housing. One of the issues I've had quite often is people who come to us and want to continually take 2-bedroom homes and make them into 4-bedroom homes or that sort of thing. It really cuts into the housing stock that we do have in Evanston, and part of what makes Evanston the community that it is. But with that said, we, as I mentioned, do have 9 standards that we must find are met. Because of the fact, just general feeling on how the board is leaning, I will note that it takes 4 concurrent votes, either for or against a project, in order to have it move one way or the other. I don't think we're going to reach that vote tonight, so it will probably be continued on for a vote at the next meeting, where people will have the opportunity to have looked through the transcripts and then record their vote. But with that said, let me get to the right standards. There's only 7 of these. I was going to give you a special use. Number 1, the requested variation will not have a substantial adverse impact on the use, enjoyment, and property values of adjoining properties. We have heard some comment from one neighbor who feels that it will have impact. We've also received documentation from the neighbor who would probably be most impacted, which is the neighbor to the east, I believe, saying that she had some concerns, she or he had concerns, but those were addressed in the document that were given to us. So whereas there probably will be some impact, I do not feel that it will be substantially adverse, and so I believe that this standard has been met. If at any point, as going through the standards, people disagree with me, just feel free to state it at that time. Number 2, the requested variation is in keeping with the intent of the zoning ordinance. While it is the intent of the zoning ordinance to produce as many off-street parking spaces as we can in order to get traffic off, or to get parking off of main streets, we also do have to balance that with such things as housing stock, exactly what we're allowing to be built to accommodate that parking. And so I feel that this standard has not been met, but I will ask if anybody has a differing opinion.
No, I disagree. We're not increasing the bedrooms of this home. We're adding a small family room and increasing some storage and garage size. I don't see that as, it's not going to affect the property value of this particular home to such an extent that it's going to alter the ability of some future buyer to buy into the neighborhood at a sort of a starter home price. It's still going to be a 3-bedroom, 1.5 bath. So I don't see that it's at odds with with that aspect of the zoning ordinance.
Thank you. Number 3, the alleged hardship or practical difficulty is peculiar to the property. As I mentioned before, we have someone who spoke to us who's on one of these half lots where we end up with 4 houses on what were technically 2 city lots. This is not uncommon in the city of Evanston. I think it is a little unique that we have the owner of the property with the larger of the 2 spaces coming to us. Quite often it's the smaller space that is coming to us to ask for such things as lot coverage or impervious surface, those sorts of things. But I am willing to concede that there is a uniqueness to this property, so this standard has been met.
I disagree. I think these properties are very common throughout Evanston, and we're not trying to go around a a landmark tree. We're not trying to do any of that sort of thing. There's no particular grading issues. So I don't see anything that is unique to this property that requires the variance.
So I think we're at a 3-2-1 vote there. Number 4, the property owner would suffer a particular hardship or practical difficulty as distinguished from a mere inconvenience if the strict letter of the regulations were to be carried out. I have a little bit of an issue here because of the fact that we are creating the garage in order to put a family room in a house. And so my biggest concern is that the property was just recently purchased in this state, and we are now immediately trying to change it. And obviously, the house was purchased without a family room, and so I think trying to put one in is more for the convenience of the homeowner, and so I believe this standard has not been met.
I disagree. I noticed that the house was sold as is, so I'm assuming that there was a great deal of work that needed to be done upon the purchase of the home. I am sure that the owners, in good faith, thought that their renovations could and should include a family room. I agree with Mr. Venamore that that's a reasonable desire to have in a home in Evanston, even though I don't actually have one. But at any rate, I think the standard, in fact, has been met. I think it's going to be, they can't do their project if we don't give them the permit, so.
Right.
It's true.
So how are we voting on this one?
That standard has been met.
So I think we're at a 2-2.
Right.
Standard number 5, the purpose of the variation is not based exclusively upon a desire to extract additional income from the property. I have the feeling that this standard is met, although it obviously would improve the quality of the house. I don't see this as something that the owner is doing in an attempt to immediately increase the property value in order to sell the house or in any way to extract additional income by changing the overall structure in and of itself so that it would be moving into a higher income area. So I believe that this standard has been met. Number 6, the alleged difficulty or hardship has not been created by any person having an interest in the property. I think this is the one where we have the greatest issue in the fact that obviously putting a garage onto the property is being created exclusively by the desire to add a family room to the home. And so I believe that this standard has not been met.
Has not.
Again, I disagree. I think it's all in the way that you look at it. If you're framing it that, yeah, all they want to do is put a family room in, then sure, you could say this, you can make a very valid argument that the standard isn't met. However, if you're positing that the hardship is caused by the odd and unique shape of the lot, then it's not owner created. They need to have parking. To build new parking, it has to be a 2-car parking set of spaces, and so that's where I'm coming down on that one.
All right. And number 7, the requested variation requires the least deviation from the applicable regulation among the feasible options identified before the Zoning Board of Appeals. This particular issue, again, I think this goes a little bit to what we've discussed previously. Obviously, if you wanted to put a 2-car garage in, this is the smallest 2-car garage in that you would put. So whereas I'm not necessarily in favor of the addition of a 2-car garage, I feel that what they have presented to us, if they were going to do a 2-car garage, is the most reasonable. So I feel that this standard has been met.
Agreed.
So with that, as I mentioned before, we will not have a 4 in favor, 4 opposed vote. So I will ask that a motion be made.
On a positive one?
Yes, please.
Let me get back.
in the matter of 2727 Woodbine.
Sure. In the matter of 2727 Woodbine Avenue, ZBA case 14ZMJV-0096, I move that we grant major zoning relief to construct a two-car detached garage. Zoning relief consists of allowing a 2-foot rear yard setback where 3 foot is required, and 3 feet between a principal and accessory structure where 10 foot is required.
Second.
It has been moved and seconded. All those in favor, please say aye.
Aye.
Opposed?
Nay.
So the vote will stand as a 1 in favor, 3 opposed, until our next meeting, which will be on September 9th, in which there will be no further testimony, but we will ask the members who are not present to have reviewed the transcript, the videotape, and then to cast a vote either in favor or opposed to what was presented this evening. So it will be continued until that time. Thank you. With that, we will move to our second case on this evening's docket, which is 423 Greenleaf Street. And could that please be read into the record?
Philip Stevens, property owner, applies for major zoning relief to construct a roofed front and side yard porch. The applicant requests a 7-foot front yard setback where 24.3 feet is required for a porch, zoning code section 6419B1, and 42.9% building lot coverage where a maximum 30% is allowed, zoning code section 6827. The Zoning Board of Appeals is the determining body for the case. Documents entered for the record include variance applications submitted July 18th, 2014, standards form, zoning analysis, plat of survey dated September 30th, 2000, site plans, elevations, impervious surface area removal, list and map of properties with similar setbacks, Zoning Board of Appeals denial, August 18th, 2010, history of property, historic preservation certificate of appropriateness from June 19th, 2014, historic significance documentation, photographs of property and similar nearby properties, letter of support from Alderman Nguyen, letters of support from neighboring properties and map totaling 6, image of property, aerial view of property, zoning map of property, and Spark meeting minutes excerpt from August 6, 2014.
I'm sorry. We were just discussing the fact that that a case on this property has come before us before, and usually we look for a substantial difference in the case that's been presented before and the case that's being presented to us tonight. And I'm fine with the case that is being the project that's being presented tonight moving forward, unless there are any objections from members of the board.
I'm pretty sure I voted in favor of it the last time in 2010, so.
All right. So with that, I will ask that anybody who wishes to speak to us tonight, please raise the right hand and be sworn. Do you swear or affirm to tell the truth throughout the course of these proceedings?
I do.
Thank you. And if you would please state your name and address for the record.
Philip Stevens and Roisin Hennerty, Hennerty, 423 Greenleaf, owners of the property. We'd like to request a continuance this evening, please.
Oh, sure. That makes it real easy. So the homeowners are requesting a continuance for this evening. It is typically our policy to grant a continuance without question for at least one meeting. So with that, I will ask if there is a motion for continuance.
I make a motion for continuance to the meeting of September 9th?
Yes.
Okay.
It's been moved and seconded. All those in favor, please say aye.
Aye.
We will hear your case on September 9th then. Thank you.
Thank you.
I'm sorry, if I had known that you were going to be continuing, I would have let you go a long time ago.
Sorry.
With that, I will note that we have concluded our business this evening. I will note that we have changed our meeting schedule for September from our typical first and third Tuesdays to specifically September 9th and September 23rd. So we will be meeting here.
So we're second
here.
and fourth? Second and fourth?
Yes.
Oh, I need to get that.
So we have made accommodations, hopefully, to everyone who responded. I know some people will be out at certain times,
Maybe
but we should have quorum for those 2 days based on previous responses from people. I will note that the meeting on September 9th, because of the continuation, now will have 5 cases at it. We may look to move one of those cases, but it sort of starts a domino effect because we do have a rather full agenda coming down the road. So I will work with staff to see if there is something that can be moved, or if we can rearrange things so we have some simple cases, so we aren't stuck with 5 cases that may have people discussing pros and cons. Also, at that meeting, we were supposed to be looking at rules changes, but I'm going to push that back until the 23rd at least, just because I know with Clara leaving the board, we'll probably be getting a new board member, and so that will all work well together with that.
Wait, Clara's leaving the board? Where have I been?
Yes, you were not here last week, or last meeting, when Clara announced that tonight was supposed to be her last meeting. Due to her absence, I am guessing that the last meeting was her last meeting. So with that, thank you to her for her board service, and we wish her luck. I know she is moving outside of Evanston. I don't believe far outside of Evanston, but she will no longer be within the borders of Evanston and eligible to serve on this board. So with that, we will be asking the mayor and city council to appoint a 7th member for us. Anybody have anything else to bring? Hearing none, is there a motion for adjournment?
I move that we adjourn?
Second.
Moved and seconded, all in favor, say aye.
Aye.
We stand adjourned until September 9th.